Correct. You wait, not the hurry.
Lordship, my senior is not in town and I do not have the.
Wait, it's not, we know where we'll allow, you, but just wait after.
There, please, your lordship. Lordship, I beg to mention for item number 17, Lord,
Yes,
with the consent of the other side, Lordship. The conducting counsel, Lordship, he has some personal difficulties with the Lordship. Mr. A. Ahmed, Lordship.
item 17.
17, Lordship.
Yes, the age of the appellant.
Yes,
Lord-
ossification test report has come. We have gone through, Lordship, a copy be given to us, then the matter will be taken out the coming week.
Just wait, we
Lord-
take it out.
Lordship.
May it please your lordship, I'm praying for listing of an IS suspension or sentence this Friday, my lord.
May please your lordship. Lordship, I beg to mention on matrimonial appeal, lordship, for hearing, lordship. Any date in the next week, lordship.
Yes. At 8/2024. Passed by the special court bracket POXO, Dimaji. In special bracket POXO, case number 15 of 2024. Arising out of Juvenile PS case number 26/2024 of the period. The appellant has been convicted under section 4 of the POXO Act. Admit the appeal. All for the LCR. Returnable in 4 weeks, Mr.
R.R. Post.
R.R. Kaushik. R.R. Kaushik. And additional PP, except notice on behalf of point number 1. Notice be issued to, that is point number 2, who is the father of the victim. True. Concern OC. To the concerned police station, to the OC of the concerned police station. This is the matter after 4 weeks. Acha, wait, in the IA also. Wait, in the IA also. And this is an application under section 430 BNSS.
Okay.
Mr. R.R. Kaushik, additional people. Is given 4 weeks time to file written objection to the thing. Yes, here, madam, you have found
Lordship, I'm appearing on behalf of S. Biswas.
item.
Item 8. This is a legal aid appeal. Lordship, he is on legs in another court.
Okay, no problem. Huh? 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 Miss,
Lordship, he told me to,
Mr. S. Biswas. Learn legally pass with appeal. For the appeal. This is an appeal against the judgment dated 19/5/25 passed by the Court of the Additional Sessions Judge bracket FPC-1, Margarita, Institute. By which the appellant has been convicted under section 302. IP. Admit the appeal, call for the LCR, issue notice, returnable in 4 weeks. Mr. KK R.R. Kaushik, additional PP, except notice on behalf of the state. This is the matter of the point.
Lordship, in this matter, I have a small request. Lordship, registry may prepare the paper book so that we can praise the bill.
Come, let the LCR arrive first.
That's right.
The LCR has to come. Without LCR, there cannot be preparation of paper book. Then the IA, right? This is an application under section 430, CNS, Mr. R. Kaushik is given 4 weeks time to file it now. This is the matter of the court. Right. Right.
Please, your Lordship.
Miss L. Devi,
Levy.
legally passed. Just for the appeal. This is an appeal against the judgment dated 20/05/25 passed by Court of the Additional Session Judge Dash come special back so Morrigan in POXO case number 38 of 2021 arising out of Nikir Beta PS case number 499 of 2020, by which the appellant has been convicted under section 6 of the POXO Act, read with section 450 and 506 I think. Admit the appeal all for the LCR. If you notice returnable code, Mr. R. Kaushik, additional PP, accept notice on behalf of the respondent number 1. Notice be issued to the respondent number 2 to be served through the OC of the concerned authority. This is the matter of the court.
Lordship, there's a typographical error in paragraph 1, Lordship, in
Paragraph one.
line 4. It will be, Lordship, POXO, I've written your
Huh?
session. Typographical error, Lordship.
Doesn't.
Para 1, I think, line 4.
Line-
It will be
para-
POXO case number. It has been typed as sessions in the petition.
doesn't.
Hide your text.
Okay.
Make me your Lordship. Lordship, this is appeal against conviction, Lordship.
What is your name, madam?
My name, F. Intasli.
Miss F. Intaz appeals for the appellant. This appeal is against order. Judgment and order. Dated 17/12/2024. Passed by Court of the Additional Session Judge bracket FTC, Ranglia, Kamrup. In sections case number 11 of 2023. Arising out of Ranglia PS case number 650 of 2020. By which the appellant has been convicted
For 13 years.
376 bracket 2 small n IP. Admit the appeal, call for the LCR, to notice the tenable report, on behalf of the respondent number 1. To notice the respondent number 2. To be served to the normal action. Appellant to take steps, service of notice for the within 3 days. This is the matter of proof.
There is an IA, Lordship, for suspension.
It's an application under section 430 PNS. It's the same thing. Okay.
Object.
11.
Yes, Your Lordship, this is an appeal, my lord, against conviction, my lord.
Counsel for the application. That the defendant has been convicted under section 6 of the POXO Act. While judgment said
22/4.
22
Two.
to 2024 passed by the additional section judge back FTC that was Dibrugarh in POXO case number 90 of 2022 arising out of Moran PS case number 72 of 2022. Admit the appeal, call for the LCR. If you notice, returnable in 4 weeks with RR. Notice to be served. Number. To the OC of the concerned police. This is the matter of court.
Outline.
Heard Mr. M. Barbara, counsel for the appellant, to submit that the appellant has been convicted under section 302 APC. While judgment dated 25/4/2022, 2025, 25/4/2025, passed by the Sessions Judge Hailakandi in Sessions Case number 57 of 2017 and arising out of Algapur
Yes.
Police Station, case number 4 of 2020. Miss call for the FTR, which is RR project except from the other state. This is the matter. for you.
Outline.
Yes. Ah. Instead of healthcare, we will get PCR.
PCR.
Lordship Senior is on leg. Kindly pass out the matter for the time being.
Item,
13.
what is your name, madam? What is your name?
It's S. Begum.
And Miss S.
Begum.
Begum, appearing on behalf of
Darakullah.
Darakullah, Direct Counsel for the appellant. This is an appeal against the judgment dated 16/6/2025, passed by the additional sessions judge Barkita in sessions case number 47 of this case, arising out of Barkita PS case number 2560/2018. By which the appellant has been convicted under section 448 IPC and section 304 of 304.
Seven part two.
Is there a 307 part 2?
307 part.
There is a part 2. 307. Give me the IPC.
304 part two is there.
Let us see the charge, training of charge. Okay. 307 part 2 IPC. Admit the appeal, call for the LCR. RR Kaushik, additional PP except for your state. This is a matter of COVID. Then you're right, in the IA, you're right. This is an application under section 430. BNS. It's the RR watching additional CP. Granted for which time. No, pick up. This is the matter.
On an appeal against conviction under section 302.
And Mr. CJ Manthal and the senior counsel assisted by Mr.
T. Gogoi.
T. Gogoi, who submits that the appellant has been convicted under section 302 IPC by judgment dated
11/6/2025.
passed by the Sessions Judge Kamrup Aminga in Sessions case number 94 of 2016 arising out of Boko PS case number 196/2013. Admit the appeal, calls for the LCR, issue notice, returnable in 4 weeks, with RR This is the matter of court.
The IA notice may be issued.
In the I, right? This is an application, same,
Put 30.
same, as the others.
Mile, lip.
Please, your lordship. Lordship, I am for 15 votes. Yeah.
What is to be done? It has to be listed for,
Lordship, in this case, lordship, we have received the paperwork, but it was defective, lordship.
defective.
Defective, lordship. Only odd pages are sharp, lordship.
Odd pages.
Odd pages, lordship. Like lordship, 1, 3, 5, 7, 9, like. Even pages is not there, lordship.
It's all right. What about the I? For what?
Lordship may heard after furnishing the proper copy of paperwork, lordship.
Right. Mr.
Ayu Chaudhary, lordship.
I.U. Chaudhary, Learned Counsel for the Appellate, submits that the paper book has been served upon him. Comma. The complete paper book has not been served upon him. Only the even numbers, or odd numbers.
Odd number.
Only the odd numbers of the book has been served upon him, and not the even number. The Mr. I.U. Chaudhary can approach the registrar. We can then provide him with the requisite missing pages of the picture. This is the matter after,
After furnishing paperwork, lordship.
this is the matter after furnishing the corrective paper.
Deeply obliged, lordship.
After, this is the matter after 3 weeks. Okay. It's 17.
The report was called for.
Yes,
Lordship, authentication report was called for.
yes.
Lordship, it has been received, but let us give a copy of the same. We'll go through it, your lordship.
After the report.
Yes, it's
Well-
there. It's not flag mark, but it's there, no? It's received.
17 years, lordship, approximately. Approximately 17 years.
It's not Meenat Salah.
In.
So if it is, if he is below the majority, age of majority,
Hello.
then maximum 3 years only. Cannot punish him beyond 3 years.
And let us have the records, my lord, we'll go through it.
Let us see the authentication. Have you got it?
It's handwritten, it was there. Handwritten. my lord.
Probably in the main.
Reply it was.
Let them see, let them see.
Ayekon no?
Catching the eye or the
It's
main?
in the IAL.
That is all. 14.5. Copy of ossification, no, what is it? Opinion of the board. X-ray. X-ray ossification shows there is non-union of sentences, there is absence of union of, there is non, and there is no. So it is 15 to 17 years. It is approximately around 17 years.
Lordship, but the learned magistrate has to arrive at a finding, my lord. It's not in form, just report of the medical, if I'm not wrong, your lordship. He has to arrive at a finding, he has to submit a report.
This is so what more can you want? This is a medical board. Three persons. One is a SDM and HO, one is a dental surgeon, one is again MO. And superintendent in charge of the hospital. Just see.
My lord, it's handwritten one. But your lordship, on the basis of the medical report, the learned judge has to, lordship, arrive at the findings. It's nothing is there. I didn't find it.
The judge has to
Lordship, my lord.
Can't we arrive at a
Just yes.
finding?
Since it was directed before directed the learned judge to conduct an
Just see
inquiry.
what is the order. Let's see. The learned special force shall direct the superintendent to constitute such a medical board. The superintendent of the concerned jail shall make necessary arrangement after conclusion of the inquiry. The learned special force shall forward a fresh inquiry report for further consideration of the plea of juvenility of the applicant. It is expected that the learned special force shall complete the exercise. Forward a fresh inquiry report.
Lordship is raising which order, my lord? Order dated?
This is the last, this order dated. Order dated 9/6/25. And this medical is May. Let me see. Then the nuclear are actually. Have already been taken. Five.
Yes, my lord. 96, it was.
Thereafter again
yes.
directed.
96. 96 or 90?
9/6 is the order.
Yes.
No, after the order
9/6.
was any, so this 14/5, the one that you have just shown us, is basically the old ossification report.
Yes.
Lordship,
So they have got to conduct a fresh ossification.
Lordship.
So that is not here. That doesn't seem to be here.
No, this is a 14/5, whatever your lordship has just read, your lordship. Yes.
But order was 1996, Lordship.
Correct.
And this report was 14/5.
Correct. So there has to be a fresh ossification report has to be made.
Probably the report has not come, Lordship.
That's what.
Earlier report.
No, since the report hasn't come, Honorable Court issued reminder, if I'm not wrong, my lord, because 17/5 juvenile report has not yet been received by the concerned section from the session judge. Then,
No,
Please look at this, just look at the
9/6.
order dated 9/6/25. Just look at that.
9/6.
It is in the IA, the last order. It's a long order.
6.
Just look at para 14.
Last order 4/6.
It's not here in this report.
It's not here.
But in the website it was there.
Huh?
In the website it was there.
My record also says 9/6 order.
Huh?
My record also says, whatever I note, 9/6 order is there,
9/6 order is there.
my lord.
But 9/6 order has asked for a fresh ossification
Fresh,
report.
yes, fresh.
Last 4 lines.
See, because that 9/6 order has already taken note of the ossification, early
My
ossification
lord,
report of
my lord,
14/5.
my lord. So they are to take
So we've got to wait.
my lord.
Wait, Lordship.
Ah,
Okay.
right. Mr. Ayush Chaudhary appears for the applicant appellant. While Ms. B. Buyas, PP, APP.
Yes.
And for the respondent. Appears for the state. Mr. A. Saliman, respondent. A. Appears for respondent number 2. This court, by order dated 9/6/2020, had directed the learned special court and the superintendent of the Tezpur Medical College and Hospital to have a fresh inquiry report made for considering the plea of juvenility of the applicant appellant. Inasmuch as the opinions of the medical given in the certificate dated 14/5/2025 and 15/5/2025 were apparently at variance with one another. However, it is noticed that no fresh medical report with regard to the juvenility of the applicant appellant has been made subsequent to the order dated 9/6/2020. The registry is to send a reminder to the learned special court with regard to the earlier order dated 9/6/2025 and this order, so that a medical report with regard to the plea of juvenility of the applicant appellant can be considered by the next day. List the matter on. Give a date. What is called?
May it please your lordship, this matter on the last occasion, paper book was ordered. Lordship.
Not made till now, no?
Perfect.
Right. The parties are present. So paper proof was to be made in terms of the last order. The same has not been made till registry to prepare the paper. This is the matter. After? Oh, wait.
Right.
My lord, in this appeal, my lord, service is
It's complete.
my lord,
Ah.
complete.
Hmm.
And your lordship kindly direct the concerned office to prepare the paper book, my
No,
lord.
I don't think, because none has entered appearance on behalf of the informant or the victim. I know it's a POXO matter. But 6K. The service report I said. Yes, sir.
Yes, madam, but what about your 430? Your 430 BNSS?
Suspension does not follow.
Huh? Not aware.
My lord, at the time of hearing, my lord.
Why?
She doesn't praise it. And other side has not entered appearance. It's a POXO matter.
Today I'm not ready for hearing, my lord, in case of I am, my lord.
Okay, right. Item
Item number 19, my lord.
19, na? The appellant counsel is present No one appears for the respondent number 2, even though the Lavazima court order dated 6/2/2025 states that service in respect of the respondent number 2 has been completed.
And someone from the,
Huh?
someone is to be appointed.
No need.
No, it's required
Why?
under
Only-
the Swandipak Nayak method.
No. It's only, whereas if they don't, if they take, if they know that the appeal is there and they don't take step, it's only, see, I can understand when they come and they say they don't have they don't have money to, to
Engage a lawyer.
engage a lawyer. Or notice is not served upon them. Then I think, otherwise, each and every, if they're not interested, why should we take the additional burden? Otherwise, you show me the judgment. let us-
17. Oh, this one notification. I have got a notification.
Whatever I said. Please come. Yeah. As paper book has arrived, as the PCR has arrived, registry to prepare the papers. This is the matter after preparation of paper. We're not providing legal. That is the discretion of the court. And it does not say that it has to be provided, only if they cannot afford.
Master bless.
I took 20.
Also, we have taken steps for registered post office note, your lordship, kindly see 16/6. 16/6/25. AD card not received back,
AD card not received.
not received.
Now what to do?
Now again, we can throw PP, we can throw OC, we can send the.
Huh?
We can take steps through OC.
We can- Paper book is,
That order is not, the IA is pending, lordship.
Huh?
IA is pending.
No, the record has not been formed.
Record has come,
Record has come.
record has
Yeah, okay. So the paper book has to be prepared.
prepared, lordship. In the meantime, we'll take steps through PP to the OC.
What is the matter?
Matter 376-2F for 14 years punishment.
Okay, right. The counsel for the appellant and the additional two we are present. As CR has arrived, there is that people. Office next, office note dated 30/12 states that.
Lordship 16/6/25.
Sorry, 16/6/25 states that neither AD card nor unserved notice has been returned, has been received from the respondent number 2. notice to be served upon the respondent number two to the OC of the concerned police station.
The Dhilai Police Station.
Huh?
Dhilai Police Station, Kabi Angan. Page 4 here also.
Dilli, DILLI. PS case number, Dilli police station, in as much as the case pertains to Dilli case number 17 of 2000. Then that's all. This is the matter after 4 weeks. What about your 430? Madam, have you submitted your written objection?
File who is submitted?
Objection has been filed.
Don't have any.
Objection is
here.
You can take it up.
Today itself?
today.
I'll send you a copy.
Today I am not prepared for you.
Yeah.
Let there be service.
Yes.
Let there be service.
Yeah. Very well. What is done here?
Lordship, IA should be same prayer, adjournment, Lordship.
Okay. I is for 40. Yes, when are you filing, madam? Your written objection.
Lordship, they don't know. Actually, this I was taken by S. Jahan earlier, Lordship. So I'm not sure whether objection is filed or not, Lordship.
Not filed.
Not filed, then Lordship will have to file it. We'll file it.
How much
Lordship.
time do you want?
4 weeks, Lordship.
Miss
A Begum.
A Begum. Addition, huh?
I don't.
Where is the main appeal?
Lordship, in that case also I'll have to take instruction. I will, if not sent. You don't do anything.
It is the notice to the public prosecutor. Anyway, let them.
As name is not reflected.
Anyway, you're right, huh? Miss, the I, right, Miss, learner counsel for the learner addition is given 4 weeks time to file an objection. To stop. Then you're right. You also right, the main appeal, you're right, the main appeal. In terms of the last order dated 9/4/2025. The appellant was to take steps for service of notice upon the respondent number 2 to the office of the public prosecutor. Have you taken
I have no idea.
the appellant
Press
shall
step- press step may be taken, Lordship.
the appellant shall
After 2
accordingly
weeks.
take fresh step for service of notice upon the respondent number. Okay, fresh step for service of notice upon the respondent number 2 to the office of the public prosecutor if not taken up. Miss
A Begum.
A Begum, learned edited people shall obtain the status report with regard to the service of notice upon the respondent number 2 by the next day. List the matter after 4 weeks. What is to be done?
Lordship, she is aged over 72 years. 133 page number may kindly peruse of the legal service report, Lordship, authority report, district legal service. And she is a
133.
133 Lordship. Last.
Yes.
Copy. And
The applicant is Asirun Miss.
Asirun Nessa, Lordship. Accused number 2, she is the mother-in-law, Lordship.
Mother-in-law.
Lordship. And she is living separately, Lordship, with all respect, Lordship, as per the evidence of PW1, Lordship. And she is suffering old age. She is not in a position to move, Lordship, in the jail, Lordship. I pray, Lordship, kindly consider the bail by considering her age, Lordship. I'm also relying on the judgment of the Honorable Apex Court, Lordship. Last paragraph may kindly please. Honorable Apex Court, Lordship. Judgment, last paragraph may kindly please, Lordship.
Yeah, appeal. Where's the appeal? Giving only part, give both, huh? all.
And there is an office note, Lordship, shows that the informant, in spite of service of notice, today's report is that await service report, Lordship. Last paragraph, Lordship, middle portion, the old age of the married, Lordship. The old age of the accused and the long lapse of time from the commission of the offense can always be a ground available to give some priority to the appeals against the conviction of the accused on
This
bail.
dying declaration, where is this dying declaration?
Dying declaration, Lordship, is mentioned in the it is an exhibit, Lordship. I have a copy of that, Lordship, certified copy. And it is an exhibit 1, Lordship. LCR has come, Lordship. And some of the independent witness PW 2, 3, and 8, Lordship, they have stated that they were present first time, Lordship, while the incidents was occurred, Lordship. And there, the victim has informed them that because of while cooking, some accident was there. And Lordship, some disputes was there, Lordship, between husband and wife, Lordship. And on that day, Lordship, there was one case before the learned magistrate, Lordship, for appearance. And on that day, the said incident was happened, Lordship. Alleged incidents.
Lordship,
And-
we'll file objection next week, maybe fix. Because IA is there.
Lordship, report is there, Lordship, of the district level committee.
So,
Legal,
by pressing the IA, we'll. have
item
to
number
file objection.
22, Lordship. I pray, Lordship, considering her old age, Lordship, may consider she is a female, Lordship, woman, old age woman, Lordship. And as per report of the DLS report shows that the social
What was her role in this burning incident?
burning incidents,
What
Lordship,
was her role? What does the judgment say?
judgment say that only based on relying on the dying declaration, Lordship. Nothing.
That is why, what does the dying declaration say?
Dying declaration, exhibit 1, Lordship, it is in particular written by the doctor in presence of doctor and police, Lordship.
What does it say?
As she was saying that in her own house, her mother-in-law and father-in-law, by pouring kerosene, she was burned down, Lordship.
Eyewitnesses also there.
Yes, madam. When can you file a written objection?
Next week, Lordship.
We'll file
Next.
Let her file. Because since it's
IA, Lordship. mandatory to file an objection.
Mandate to file if we are of the view that bail should be.
Lordship,
Huh?
that is there.
And as per evidence of eyewitness lordship PW2
So let her file.
lordship. Short date, maybe she is suffering lordship with all
2 weeks,
respect on
lordship.
humanitarian ground by him.
You said next week.
No, next week, I'll file next week, the case will be there, Lordship. Lordship,
It may be
that
filed by
next week,
Friday,
the case will be
Lordship.
there.
Look, she's 70 plus.
And that is, Lordship, on Monday or Tuesday, they list the case.
Okay, we'll listen next Tuesday.
Lordship, within this, I'll file it. Lordship.
Okay, or Monday we'll file. Monday.
Lordship.
Will come easier. Correct. Now, in the IA, Miss A. Begum, additional people. Submit that she'll file written objection within this week. Accordingly, leave this matter. Just right. The answer for the applicant submits that the present application under section 430 BNSS has been filed by the mother-in-law of the deceased, who is 72 years old.
Lordship. More than 7.
Stating that the applicant had no role to play in the death of the deceased by burning.
Lordship.
This is the matter. On Monday, huh? Huh? Main case, nothing is. Nothing is. In the main case, you can say that nothing has, it goes together, nothing. Because order for paper book is already there.
Lordship, it will take time, Lordship. I pray kindly consider the bail on next
We fixed it already for Monday.
Lordship. Much obliged.
Right, Mister?
Hence, your lordship.
And take a current counsel for the applicant who submits that there is a delay in 40 days
40 days.
in filing the appeal against the conviction of the applicant under section
6 of Oxford.
by the court of the Judge Poxo Golaghat in special Poxo case number 32 of 2021. Ms. A. Begum, additional PP, submit that there were no objection if the delay is permitted. In view of the above reason, the delay of 40 days condoned. I accordingly. Before that, you write, registry to register the appeal and leave the same after a week. I is accordingly allowed and disposed.
And the day of license.
Before. Yes. Who is the parent?
No, we have to file objection.
Yes, what is your case?
For the
You are the only one in the house. I mean, in the room. It's your wife.
Yes.
And she was strangulated.
This was the allegation.
That was the allegation. No, she strangled herself.
By the accused, that the appellant.
Huh?
Was by the appellant.
Okay. But so the apparent strangulated his wife. Appears.
This was the allegation.
Was there anyone else in the house?
No.
No one.
As of the last same theory was there, but
And then you came running out of the room saying what? That he died. And the what do you call it? The PME says that she was strangulated. So what do you mean? Okay.
There is a statement given by the accused that the husband, that she was suffering from the epileptic
Epilepsy.
disease. And that was the same.
See the medical report as in the judgment, what has been stated? Yes.
They'll take marks.
Okay, yes, we can. Yeah, I think, it's very good. Okay, right in the, I heard Mr.
M. Rabban.
I M.
Rabban.
Rabani, learned counsel for the applicant who submits that this application for let me see this BNSS. See the exact word. BNSS. Say, censor for the appellant, applicant appellant, and Mr. R. Kaushik for the additional PP. This is an application under section 430 BNS. For suspending the sentence pending disposal of the present appeal and release of the appellant, applicant appellant on bail. The applicant's case is that he has been convicted under section 302 IPCC for having caused the death of his wife by the court of the Sessions Judge RB Law. By judgment dated four 1/24. Passed in SC number 44/2011 arising out of Bakalia PS case number 63 of 2010. Is that the appellants of the submit that the appellant has thereafter been sentenced to undergo life imprisonment under section 302 IPC and imposed a fine of rupees 20,000 in default simple imprisonment for 6 months. The appellant's counsel submit that the incarceration of the applicant in judicial custody has led to financial hardship and instability of the petitioner's parents,
Children.
children, and parents also.
Yes.
Huh?
Parents means only mother is living.
Mother and children. Further, there has been a loss of family reputation and social standing. The emotional trauma and distress that has been inflicted on the petitioner's children, applicant's children, due to his incarceration is also leading to them withdrawing from the community. The applicant's counsel submit that the impugned judgment is liable to be set aside in as much as the prosecution has not been able to prove that the applicant was the cause of death of his wife. In as much as the applicant's wife had died due to what? Epilepsy, due to epileptic seizure and not due to strangulation. Correct. He accordingly submits that in view of the above, the sentence imposed upon applicant is suspended. We'll final disposal of the business. Mr. R. Kaushik, the learned additional PP, on the other hand, submit that though the applicant was last seen with his wife and though he had taken the plea that his wife had died through an epileptic seizure, the evidence of the medical doctor PW 5 had proved that PW5 had proved that the death of the applicant's wife was due to asphyxia resulting from throttling strangulation. Next. On considering, now he accordingly submits that there be enough evidence to show that the applicant was the cause of the death of the wife, the appellant, whose applicant's application should be this. Next part. On considering the fact that the applicant was last seen together with his wife. And on considering the evidence given by PW5, who is the doctor who had conducted post-mortem examination on the victim, we are of the view that further, PW3 in its evidence and also stated that he woke up after hearing a hue and cry from the house of the applicant. When he went to the house of the applicant, he saw the dead body of the deceased lying on the bed. And that the applicant was the only person present in the house. On considering all the above, we are of the view that the prayer of the applicant for suspending the sentence cannot be allowed at this stage. Accordingly, the application of the applicant is rejected. Yes, next, is there in the main case, right? As the PCR has arrived, registry prepare the people. This is the matter of the court. With this back, get the PNF.
Timing added to.
Yes. So are you all,
Respondent number, respondent.
so can it be sent for mediation?
The interest was for mediation because for last 15, 16 years, there have been official or unofficial mediations. And thereafter the London Trial Court, Family Court has passed the order for permanent alimony of 1 crore. And thereafter, like, there has been delays for many reasons. So like,
So you are not
trust more on our before to passing a contested order.
So that's all. If it is cannot be done, then Miss
M.
Dave.
DV.
Huh? DV Dave.
DV.
Miss M. Dave appears for the appellate. Mr.
Dr. N. Deca.
Dr. N. Deca, learned counsel for the respondents, submits that the respondent is not interested in submitting, is not interested in referring the matter for mediation in as much as the only object of the appellant is only to delay the matter. He submits that the matter may be decided by this. In view of the above, this is the matter when?
That's of any date, Lordship.
This is the matter after 2 weeks.
If a date can be fixed, Lordship.
Records are there. Because this is the matter. Is there a paper book required? No. Huh? If is paper book required out here? Not required. No.
Paper book is probably there, Lordship. I have seen. Paper book is given.
There is no paper. Is paper book required in a MSCT in a McAfee?
But I have seen, I have been supplied with paper book.
This is the matter after 2 weeks for admission hearing.
Yes,
No.
Lordship.
No, for hearing, Lordship.
For hearing.
What to say, admission hearing.
What is it for hearing?
For hearing.
Oblige.
Allow that. We allow this. Right, Mr. KP Partner appears for the applicant. Submit.
Appearing as a legal aid counsel.
There is a legal aid counsel who submits that there is a delay of 151 days in filing the appeals against the judgment convicting the applicant under section 6 of the POCSO Act. Mr. R. Kaushik, learned additional PP submits that he has got no objection to the delay being followed. Via the above, the delay of 151 days in filing the appeal is followed. Registry to register the appeal and list the matter after review. I is accordingly allowed and disposed of.
Deeply obliged.
May I please with your lordship? Lordship, there is a delay of 47 days,
Notice was issued.
section 5.
I thought this is the first time.
Yes.
Is it allowed?
Order dated 7/4/2025 passed by the learned Principal Judge Family Court 1.
Okay, right. The heard miss,
Devasri Chakraborty.
your name is not here. Miss
Devasri Chakraborty.
Devashi Chakrabarti appearing on behalf of
SC Wishes.
the SCB submits that there is a delay of 47 days in filing the appeal against the impugned judgment and order dated 7/4/25 passed by the learned principal judge, Family Court 1, Kamru M. In FC bracket 7, case number 451 of 2022. The applicant's case is that though the impugned judgment and order was delivered on 7/4/2025, the applicant was not informed of the same by his engaged counsel, and he came to know about it only in the last week of May 2025. Thereafter, a delay of 47 days occurred due to the time taken for obtaining a certified copy of the impugned judgment and order. Consulting a counsel and filing the present appeal and application. On considering the grounds taken by the applicant, we are of the view that sufficient cause for the delay has been made. Accordingly, the delay of 47 days is controlled. Register the appeal and leave the same after review. I am currently allowed and discussed.
7.
I is for the condoning the delay of 26 days, lordship.
Heard, Miss
Came Silvia.
James Saikya doesn't pass it for the applicant. So submit that there is a delay of 26 days in filing the appeal against the impugned judgment and decree dated 23/4/2025 passed by the learned principal judge, Family Court number 1, Kamrup M. at quarter in FC bracket C number 933/2020. Whereby the petition filed by the applicant under section 13 bracket 1 bracket IA small of the Hindu Marriage Act 1965, praying for dissolution of marriage by a decree of divorce has been dismissed. The Applicant, the applicant's counsel submits that the applicant could not submit the appeal on time due to the petitioner being a very sick person undergoing medical treatment. As such, the delay of 26 days has occurred due to medical reasons. Considering the delay of the grounds of delay filing the appeal, we find the sufficient cause for the delay has been made up. The delay of 22 days accordingly condoned registry to register the appeal and is the case after review. I is accordingly disposed of and allowed in the suit.
Much appreciated.
Supplementary orders 38 and 1.
May I please your lordship?
Yes.
My lord, Peak Potoki will be appearing in this matter, my lord. Can it be after some time, my lord?
Objection of appeal, sir.
302.
My lord, IA is, we have filed the IA for two
So
accused.
against her, we need to file an objection then.
Why we dispose of the entire thing? Why do you, since the paper book is ready?
My
Lordship, actually paper book is also not
My lord-
provided to us.
My lord, it was already in fixed for early hearing. The one direction is,
So we'll hear it.
But-
The date.
in the mean,
Yes, Lordship, may please.
No point doing things piecemeal. out.
maybe next week, my lord. Next week, my lord.
Only I pay for a paper book.
You have not got.
Maybe your Lordship is aware of the office, sometimes they don't provide.
My lord, because one of,
Any eyewitness outcome?
no, that was there. I'm not prepared on that part, my lord, but in between, my lord, one of the accused got very sick, my lord. An additional affidavit was filed in the IA.
I think there was a witness, eyewitness, no?
So, my lord, next week, any date for hearing, my lord. My lord. My lord.
Okay, on the prayer made on behalf of the applicant appellant. Is the matter when?
Next week, any date, my lord.
Huh? Is a matter. Okay. Yes, madam, what to do about Ms. Rian, what to do about the paper book? Probably your office has got it, I'm quite sure.
They must have got it and must have misplaced it somewhere.
Then, what are you going to do?
Then I get the Xerox from her.
I said, they mean,
Yes,
tell,
Xerox from her.
submits that he'll make a photocopy of the paper, for the copy of the matter. That is it.
Okay.
Hearing that is 58.
This is an appeal preferred by the state of Assam
Yeah.
against the order of acquittal, your Lordship.
Sheila.
Oh.
Yes, I was.
So that side.
It's all right. We always look at the state this side.
Yes, my lord, that's why I asked madam whether she.
Appeal against acquittal.
There are 15 numbers of witnesses, your Lordship.
15 numbers of?
Witnesses. Prosecution witnesses. And your Lordship will find the judgment at page 74 of the paper book, madam.
Yes,
Lordship, may I straight to take your lordship to the appreciation part, my lord? It is at page 84. Last but second paragraph.
yes,
I have appreciated the rival contention of both the parties in the light of the evidence and record. In the instant case on 28/4/2005, FI was lost by Muhammad Hamid Ali, the father of the deceased Manwara Begum, alleging that since the evening of 25/4/2005, his daughter Manwara Begum was missing, and when on 28/4/2005 at about 1 p.m., her dead body was recovered from a pond from the backside of the house of one Muhammad Saifuddin, and he suspects that she was kidnapped and murdered by accused Muhammad Samsher Ali, Samnur Ali, Mir Hussain Ali, Mrs. Julika Bibi, Jaina Bibi, and Rafiq Hussain. So let us first take the note of the FIR and the circumstance as has been pointed out by the defense. The informant, Hamid Ali, examined himself as PW1 and he has exhibited the FIR at Exhibit 1. From the FIR, it is found that Manwara Begum was missing on 25/4/2005. And in his evidence, also, PW1 has stated that on that day, his daughter went with the accused Jerina, and instead of having knowledge that Manwara went with the accused Jerina, till a recovery of the dead body of Manwara, no FI was lodged. Again, from the evidence of PW Amina Begum, who is the mother of the deceased, it is also found that her daughter Manwara was in love with the accused Mir Hussain, and as there was some defamatory on the upper lip, some deformity on the upper lip of her daughter. As such, the family members of Mir Hussain did not agree to their marriage, and as the accused persons were absent at the time of discovery of the dead body of Manwara, and thereafter, so she suspect that accused persons committed murder of the daughter.
but why the family members of Mir Hussain?
Yes.
Who is the family members of Mir Hussain? The other side.
Yes, this is an accused person. Yes,
the
accused
boyfriend's
person,
family.
boyfriend and father, as well as other relatives. From the above discussion, found that after recovery of the dead body of Manwara, the informant suspecting the accused persons filed the FIR against them. Again, the PW2 also suspected the accused person as the family members of the accused Mir Hussain did not agree to the marriage between Manwara and Mir Hussain. But suspicion cannot be treated as proof of guilt. In a reported case of so-and-so, Honorable Supreme Court has held the suspicion, however grave, cannot take the place of proof. There is a long distance between may be and must be. In criminal trial, presumption of innocence by accused is a human right, and when there is possibility of true view which favors the accused should be upheld. On the other hand, PW1 in his evidence stated that Manwara left their house on 25/4/05 along with Jerina after 12 noon, and the PW2 also stated that on that day Manwara left their house along with Jerina. As per the evidence of PW3, Manwara was last seen along with the accused Jerina on 25/4/2005 at about 12:30 p.m.
Jerina is a female.
Yes?
Yes.
Yes. As per the evidence of PW12, on the day of incident, he made Manwara at about 1 p.m. at Borua Pharmacy, Nalbari, and she was accompanied by Jerina. From the evidence, it is found that Manwara was missing since the afternoon of 25/4/05, and a dead body was recovered on 28/4/05 at about 1 p.m. and she is last seen together along with Jerina on 25/4/05 at 1 p.m. So there is a vast gap between the point of time when the deceased and the accused Jerina was last seen together and the recovery of dead body of Manwara Begum. In the case of Kesha versus State of Maharashtra, reported in 2008 SAR 15, Honorable Supreme Court has held that the last seen theory is relevant only when death is proved to have been taken place within a short time the accused and deceased being last seen.
What was the medical report? What does it say? When did
that exam PM report at page 94, minor. Time since date, I did not find it, Your Lordship. '94 onwards. Page 95, the condition of subject stout, so and so, emancipated, decomposed. A dead body of a young lady about 18 years.
date of death or time of death, nothing can be made out.
Okay. Let us see the opinion of the doctor, your lordship, if something could be discerned. PW 11, my lord.
It's like. Yeah.
Nothing is said. Date was caused 3 days before, approximately. That is given, my lord. So, lordship, 29/4, 3 days before it would be lordship 26. Hmm? Indian peso মানে Indian আগত হলে 27, 20, 29. Yes, 25. Yes, that is the date she was last seen in Jerina. But your lordship, the time gap is actually it's longer, my lord.
Everyone is that. Everyone is. What night? What color?
Lordship, may I proceed further, please? 87. Second paragraph. On the other hand, the PW1 deposed. On the other hand, the PW1 deposed he has deposed that he came to know from Fatima Bibi and Bulu that they saw that Manwara was entering in the house of accused Samsir and also heard crying of Manwara inside the house of the accused person. But said fact is not mentioned in the FIR. To his denied the suggestion that he did not state the said fact before the IO, but the IO in his cross-examination stated that PW1 Hamid Ali during investigation did not state that Fatima and Bulu heard the crying in the house of accused Samsher Ali and both of them reported about the incident. Such vital omission amounts to contradiction. Moreover, prosecution side has not examined said Fatima and Bulu as witness. So it can be presumed that if examined, they would not support the prosecution case. Though PW1 in the FIR alleged that the accused person had kidnapped his daughter Manwara and committed murder, but there is no iota of evidence about the alleged kidnapping of Manwara Begum. From what has been discussed above, it is found that the prosecution case is based on concoction and surmises without any convincing and causal evidence to inspire confidence on the credibility of witnesses, and the evidence on record found wholly unreliable. In the circumstances of the case and considering the evidence on record, it appears that the prosecution side has failed to prove the ingredients of section 299 IPC beyond all reasonable doubt that the accused person caused such bodily injury to Manwara Begum with intention of causing her death to make them liable for punishment under section 302, as a result of which the accused persons are liable to be acquitted on benefit of doubt. So these were the appreciation. Now I take your lordship to the circumstances which goes against defense manner, which is in favor of the prosecution. Lordship, about 12 noon on 25/4/2005, Jerina and Manwara returned. Then they drank water, and Jerina asked Manwara to accompany her. Then Jerina happens to be the sister of one of the accused. Then 28/4/2000, Jalil.
How many accused are there altogether?
My lord.
How many accused are there?
6.
6, my lord.
Six.
Charge sheeted accused 1, 2, 3, 4, 5, 6, 6.
And who is the boyfriend?
Mir Hussain.
And Jarina is what? Related
Sister.
to
Yes, of the accused. One of the accused person. Then my lord, yes. Fatima and Bulu saw Manwara.
Who is Fatima? What is
These two witnesses were not, they were neighbors, but they were not examined.
They are not prosecution witnesses.
No. Let us see the charge sheet, whether they were charge sheeted, my lord, or charge sheeted witness or not. It's 106. 9, no? Fatima Bibi, yes, her is the name and address witnesses. Her name is there in the charge sheet. Fatima Bibi and Buliara Begum, page 111.
Yes.
Lordship, here, this Fatima and Bulu, who heard the victim crying, and they found like she was inside the house of the accused persons, my lordship. They were not examined.
Okay.
But the learned trial court has come to a finding, your lordship may kindly see page 87, that Fateh and Bulu heard crying in the house of accused Samshel, and both of them reported about the incident. Such vital omission amounts to contradiction. Moreover, prosecution side has not examined said Fatima and Bulu as witness. So it can be presumed that if examined, they would not support the prosecution. Then accused persons were evading arrest. They were absent from the date when from 25/4 itself, lordship, they were not found. Their room was found in lock and key position.
When was FIR filed?
FIR was filed on 28/4. The delay in lodging the FIR
FIR
The-
on 28/4.
because she was lordship.
28/4/25.
Yes.
Then what were y'all, what were the parents doing, parents of this girl doing prior to filing the FIR? You see, your daughter doesn't turn up
My lord.
on one day. One day doesn't turn up, when you keep 25/4, they went out, correct?
My lord.
Then
28/4.
25/4 she went.
25/4 she, yes, went
out.
missing.
Yes,
And 28/4 her dead body was found.
and it's your daughter.
Yes.
Now, what did they do? Any step? How old was the deceased?
18 years.
18 years. Look, my daughter is 23.
Still daughter is a daughter, your lordship.
One day to I'll be.
My lord.
Yes.
Only,
Yeah.
yes, my lord. Very true.
Not only myself, I'll wake up the entire neighborhood in
Yes,
such
yes,
a
very
joint.
true, very true, my lord.
All cousins, everyone.
Yes, my lord. Then there's extrajudicial confession before villagers by Jerina that victim was in love with accused Mir Hussain, that the brother of her. And at the time of her death, she was 2 months pregnant.
Perfection. By?
By Jerina, one of the accused person, that she was in love with her brother, and she was carrying 2 months pregnancy. And as she had deformity on the upper side of her lips, the family members of Mir Hussain did not agree to the marriage.
Where is the medical report regarding her pregnancy?
It has not come.
You are a fetus.
Yes.
Then surely be there.
It is not.
Lordship, let us see in the PM something has come out.
Nothing. 700%. $97. 98. Huh?
Fatima? No, she was, my lord. No, they did not turn up. Yes. The name in the names are there in the charge sheet. Buluara and Fatima. Probably was taken, that's why their name in the charge sheet. Then there was lordship, the father of the accused person. Mir's father informed PW5's father that how he killed Manwara.
Huh? Father of?
Father, one of the accused person informed PW5, in fact, informed PW6 that last night Mir's father, that one of the accused person, informed PW5's father that how he killed Manwara.
5 informed PW6. That's what
Yes.
you said.
That
PW5
last night, Mir's father, that means one of the accused person,
Mir is the
Mir is
boyfriend.
the boyfriend, and his father's name is some state.
Okay, so Mir's father, was he made a accused also?
Yes, they are altogether 6 accused person.
So PW5 informed PW6
Yes,
that Mir's father did what?
yes. Mir's father informed PW5's father.
Acha, PW5's father.
Yes, how he killed Monwara.
Five to like it.
Okay.
Five turned to be hostile.
Huh? Five hostel.
No, everything
21.
cannot be thrown out, Your Lordship.
Page 22.
These are the circumstances. I did not find anything more than that.
Mir's father killed Manwara.
How he killed.
How did he kill?
Yes. The manner he killed this one.
Then what was the role of Karima? How did she kill? Or what? She helped her father kill?
Because she was last seen, although the gap is more, she was last seen with the victim. They went somewhere, then came back home, then had water, then again went back along with her. The deceased along with Jaina went
That
out.
is the common intention.
Common intention maybe the deceased had a love affair with this one. She was carrying pregnancy, and since she has got deformity on her face, that's why they were not agree. It has come up on record.
Where is the pregnancy?
That report is not there, madam.
Can we take note of that? Supposing you are sitting here
My
and
lord.
I am standing there, and I give you the same argument, will you accept it?
Nothing is on record. Whatever has come out from the mouth of the witnesses, I have deposed, my lord.
But you see, you are going beyond. You are saying this, that pregnancy. But if there's nothing to support,
The case of the prosecution.
yes.
But at the same time, how did the learned trial court has come to a finding? If these two witnesses have come up before the court, they did not support the case of the prosecution. That's a wrong finding, my lord. Nothing. In 106 pardon may also come because allegations and
It is not an enclosed space. They went out. The whole world was there.
her voice was like she was screaming, and her voice was.
That is again.
But from these two witnesses, they are not
The
before the
witnesses
court.
are not there. Yeah. You see, and yes, 25/4 they went out. FIR filed only on 28.
28. Whether any GD entry, nothing is on record, my lord. Lordship.
What could have happened was that maybe she slipped and fell or something in the pond. Could be. We do not know.
No, injury, there are injuries.
Could be. You see, when falling down also you can have injury.
But Lordship, body for wherein he has received injury.
No, I'm saying this is all hypothesis.
Hypothesis, yes.
Same as your arguments.
My lord. I'm handicapped, your lordship understands, because everything is like whatever is done by the trial court below. I have nothing beyond whatever is before me.
So when supposing we accept that two interpretations are possible.
So whatever is in favor of the. But may I see if your lordship permits if any entry is made?
Please,
Like,
you're
what do you
welcome.
want to do? TD has been open on 28/4, sir.
Huh?
On 24 only.
28 for on.
Right.
No explanation for the delay. Now, can you condense your points in, what is your basic points? I don't know. Give me
Basic
1, 2,
points,
3.
Motive, there may be motive because
No,
of
no.
circumstantial
Maybe
evidence.
motive. Can I?
Motive, my lord, because lordship, the pregnancy point.
Okay, okay, we'll record. Maybe motive. Maybe motive due to maybe pregnancy.
No, not maybe pregnancy, my lord.
Due to 2 months pregnancy.
2 months pregnancy, and as the lordship, the family members of the accused persons were against the marriage because of the deformity on the
Okay.
part of the victim
Due
girl.
to deformity.
On the part of the victim
uh,
girl.
Declining marriage. Rejecting marriage.
Yes, my lord.
Rejecting.
No, deformity on her upper lip.
In her upper lip. She's got a cleft
Lordship,
lip.
there is explanation. May I take your lordship the FIR at page 4?
Rejecting marriage proposal. Or what?
Yes, yes.
Where is that evidence rejecting marriage proposal? Is it there?
No, sure, witnesses have said, mine.
Yeah, I want to see. Let me see who has said that.
Regarding this one, my love affair, it has come up on evidence from the mouth of PW3.
Okay, love affair, so we accept. Love
Okay.
affair, okay. But then how does that matter? Where is that?
Then regarding the deformity, my lord.
No, where is the marriage proposal being rejected?
Yes. Page 13, last portion.
Page 13.
Yes.
Page 13, page 13.
It is not a fact that I did not state before the IO that the accused Jaina made admission before the police and the local people that my daughter was in love with the accused Mir Hussain, and due to some deformities on the upper lip of my daughter, the family member of Mir Hussain did not agree in the marriage between Mir Hussain and my daughter.
But this is only a suggestion.
It is a suggestion.
It's only a suggestion.
Oh, regarding 2 months pregnancy, page 13 only.
Huh?
Lordship, accused Jaina Begum admitted before the police and reports in presence of villagers that the victim was in love with the accused Mir Hussain, and at the time of her death, she was pregnant for 2 months. As there was some deformity on the upper lip of my daughter, the family members of the accused Mir Hussain did not agree to the marriage between my daughter and Mir Hussain.
This is the evidence of the father.
Mas Fatima, mother.
The mother of the deceased.
Explanation part, may I take your lordship to the FIR, page 4?
Okay, assuming that yes, this has happened. So how do you connect this with the murder?
With you?
How do you connect this with the death of the deceased?
The connection, there's a missing link, I should admit. Because what happened after that, since the Jaina had taken her away, then thereafter there's nothing. In between two of the witnesses, not the witnesses, it has come up on evidence that Bulu and Fatima has heard a scream, and it was inside the scream of the deceased.
Well,
Yes, my lord, it has come up in evidence.
nothing. Scream of the deceased, scream of crying.
Yes, my lord, it was there. Lordship, page 10. It has come up in the examination chief. Just fifth line from the bottom of examination chief, my lord, last few lines. I came to know from one Fatima and Bulu who were the neighboring women of the accused persons that they had seen entering Monwara Begum.
Page,
Page 10. Few lines just above the cross minor.
there.
I came to know from one Fatima and Bulu, who were the neighboring women of the accused persons, that they had seen entering Monwara Begum in the house of accused Samsher Ali. They also mentioned that they heard cry of Monwara inside the house of the accused person.
Cry, not screaming, cry.
Cry is
Now, this,
because Ashim, the house of Bulu is nearby to the house of accused Samsher, and the same of her husband is Mumtaz Ali.
now, Shamsher Ali lives in the
Father of the
boyfriend.
boyfriend.
Shamsher Ali is
Yes.
boyfriend. And boyfriend's name is Mir.
Mir.
Hamid.
Yes. Mir Hussain.
Mir
Mir
Hussain.
Hussain. So since it has come up on evidence that she was like, although these two.
When did she enter this house?
25-4.
25-4.
Regarding the delay, some explanation is there in the FIR.
You do not affect this. It's difficult. It's difficult before the public. Then, okay, we did the okay. Then why this issue then issue between the important? We did explain the grain audio cutting. Grammar facility. Have the cry that if you are down, it is not a bad thing. We did not do that. Is there, you've got the record with you?
Yes, Mama.
Did this lady, this PW1, MD Humid Ali, or
Hamid Ali. Amina Begum, my lord, PW2.
no, one
One is Hamid Ali, informant, father.
father. Did this father
Yes.
give any 161 statement
Yes, my lord. Let us see.
stating that he had heard Fatima and Bolu
Yes.
stating that he
Lordship.
had heard that daughter crying?
My lord. Hamid Ali. Married age. মোৰ নামো ঠিকনা কোৱা মতে সত্য হয় মই আগতে চাকৰি কৰিছিলো বৰ্তমান ঘৰতে আছো মোৰ ল'ৰা ছোৱালী বোৱাৰী সৈতে পৰিয়াল প্ৰায় 10 জন যোৱা ইংৰাজী 25/4/2006 তাৰিখে মোৰ তৃতীয় ছোৱালী মিছ মনোৱাৰা বেগম মোৰ ঘৰৰ পৰা নিৰুদ্দেশ হয় আৰু দিন ধৰি মোৰ ঘৰৰ লগতে মোৰ গাঁৱৰ বহুতো লোকে বিচাৰ কুচাৰ কৰোতে পোৱা নাছিলো কিন্তু আজি দিনৰ প্ৰায় 1মান বজাত মোৰ হেৰুৱা ছোৱালীজনী মোৰ ভাই সাইফুদ্দিন আহমেদৰ ঘৰৰ পিছফালে বাহনীৰ মাজৰ আৰু so খাৱা এটা গাঁৱৰ লোকে দেখা পায় আৰু মোক লগতে ঘৰত গোচৰ খবৰ দিয়ে তেতিয়া আমি গৈ ছোৱালীজনী প্ৰত্যক্ষ কৰো লোক আৰু বহুতৰ মতে মোৰ ছোৱালীজনী আমাৰ গাঁৱৰেই মহম্মদ শামছেৰ আলী চন্দ আলী মীৰ হুছেইন আলী জালিকা বিবি মিছ জাইনা বিবি ৰফিকুল হুছেইন আদি বহুতে লগ লাগি মোৰ ছোৱালীজনী অপহৰণ কৰি লৈ গৈ মাৰি চাইফুদ্দিন আহমেদৰ ঘৰৰ পিছফালে বাহনীৰ তলত পেলাই থৈ যায় পদকীয়া কেইজনৰ ওপৰত মোৰ সন্দেহৰ কাৰণ হল ঘৰত কোনো ছোৱালীজনীও হেৰুৱাৰ পিছত ছোৱালীজনীৰ চিঞৰ বাখৰৰ শব্দ গাঁৱৰ লোকে পদকীয়াৰ ঘৰত শুনিছিল Yes. কিন্তু প্ৰথম অৱস্থাত মই লগতে কোনেও ঘটনাৰ সন্দেহ কৰা নাছিলো কাৰণ ছোৱালীজনী প্ৰায়ে টিভি চাবলৈ সিহঁতৰ ঘৰলৈ গৈছিল গতিকে মোৰ ধাৰণা হয় পদকীয়াজনী ছোৱালী মনোৱাৰা বেগম হত্যা কৰে Let us see if
But here he never mentioned.
yes, your lordship is very much.
So Fatima and Bulu are not there.
No.
So that hypothesis also goes. This evidence, in his evidence, he has said that I came to know from one Fatima and Bulu,
Yes.
who were the neighboring women of accused person that they had seen entering Monowar Begum in the house of accused Samteral. They also mentioned that they heard cry of Manowar inside the house of the accused. Huh? Now doesn't seem to be a very what?
Lordship, but
Well, with
Buliara, her statement is there, 161 statement. Buliara, that means Bulu. She heard the scream and the cry of her.
Not a witness.
That your lordship.
She did not
This
give
is there
evidence.
not before. Yes.
Just wanted to see whether this PW1, his evidence was reliable or not.
Got that out.
My lord.
What?
My lord. Even other one also said in 161, but they are not before the court.
Anything else?
Explanation is given why, because they were in like extensive search for the girl, my lord. It is mentioned in the FIR. I would like to inform that my third daughter, Monwara, has been missing since the afternoon of 25th. Though we made extensive search for her for the day, we could not trace her out, but around 1 p.m. today, the villagers saw my daughter lying dead in small ditch in the mid of bamboo groves located in the rear side of my younger brother, Mondot Saifuddin Ahmed's house. Suspicion is there, the names are mentioned in the FIR.
But then
PW6 also says he saw her entering the house, but did not see her returning from there, from the house of accused person.
when did they see? What time?
Lordship, he mentions about 25-4. PW6. I knew.
No time.
No, Lordship, it's given. I knew this is Monwara. Incident took place on 25-4. And at 8 a.m. on the day, this is Monwara went to a pharmacy at Madrasa shop with accused Jerina. Both of them returned and entered the house of Hamid Ali. Thereafter, both of them went to the house of Jerina. but I did not see Manwara returning from there. In the evening, I saw a gathering in front of the house of Hamid Ali. So they were searching from the evening itself, Sir Lordship. The normal Lordship, they will search because like nothing abnormal, my lord. Since the evening on 25/4, they were searching for the birds. It has come up on evidence. The villagers said that since Monowara had love affair with Mir Hussain, she might elope with him. So like they were thinking.
But boyfriend is also, so who was convicted? Ashik.
No, they were acquitted.
All acquitted, sorry, all
But they were charged sheeted.
So,
All of them.
so if she's going to elope, where is the question of the boyfriend being charged?
No, they were like under suspicion that the girl had eloped with this one of the accused person since she had a love affair with him. Then thereafter they discovered a dead body. Lordship, I have nothing to submit more, my lord.
Yes. Difficult case. I don't know why you all filed the appeal. You could not have filed.
It was filed in 2017.
Yes.
Lordship has seen, my lord, in the entire evidence, my lord, prosecution miserably failed, my. And so far, this Jerina, my lord, in cross-examining, Lordship kindly turn to page 26 for a moment, my lord. 1, 2, 3, 4, 5, 6 paragraphs, 6 lines from bottom.
Yeah.
I did not see Manowara and Jerina entering house of the Samsar. Jerina house is situated at some distance of my house. In cross, she said, my lord, she did not see it.
PWC.
My lord, just now my learned friend has relied upon. I did not see. It is not affected 12 Manora. Number please. Again, she said, my lord, I do not know as to where Monora had gone after coming out of house of the Hamid on that day.
That is in the morning also. No, it does not even time. How? Family party is five people. Your own. Then. That's good. No. Anything else?
Lordship has already rightly pointed out, my lord, delay part is also not there. And
What is not there?
delay, my lord, why 3 days they have, my lord, my lord, nowhere mentioned. Then no,
Sitting for 3 days. Probably.
my lord, sitting and my lord, another thing, PM report also does not indicate about the pregnancy or anything. Rather, it says for my lord, for the liver, page 98, my lord, PM report. 98 is the opinion, my lord. Opinion says, my lord, in my opinion, that is due to the internal hemorrhage from the rupture, liver and shock. And no pregnancy, nothing as such has been brought out, my lord.
The 60% also was not present in the village, he was in his place of work.
And timing is also not there, my lord. And moreover, my lord, PW6 also made another contradiction, my lord. They questioned Jarina, why did not you any investigation on 24th? Samsher was not present in the village. I was not present, my lord, Samson. In his place over, last line, page 27. Basing on the assumption, my lord, lordship is aware, my lord, and common intention over and above, my lord, not a single word has been uttered, my lord. Why shall I be there, my lord? Rightly pass the order by the trial court. So in view of the fact, my lord, there is a retina of judgment, lordship is aware, my lord.
No, not at all.
Lordship,
Yeah, but-
so miserably failed, my lord. The instant appeal could not have been survived, liable to be dismissed.
In fact, no, summons were sent to these two witnesses.
That did not turn up, that did not make any effort, my lord. Warrant taken, issued, there is a lot many things, procedure is there now. And basing on the assumption and presumption, my lord, nobody should be, my lord, entire family. My lord. So in view of that, my lord, the case miserably failed.
Okay. Right. Heard Mr. J.I. Babuya. None counsel for this. No, sorry. I heard Mr. B. Buya. Then an additional PP for the state. Bracket appellate. Also heard Mr. J. Babuya. Then counsel for the respondent.
The respondent response.
The appellant has filed the present appeal challenging the acquittal of the respondent by the then by the court of the session judge of Nalbas in sessions case number 18/2007, GR case number, GR case number 327 of 2000. From the charge under 364 302/34 IPC. The prosecution case, the case of the appellant is that case of the appellant is that on 28/4/2025, the one Hamid Ali, bracket prosecution witness number 1, lodged an FIR at Belthor Police Station, alleging inter alia that his daughter Manuwara Begum was missing since the evening of 25/4/2020. Though a search had been conducted, he was untraceable. However, on 28/4/2005 at around 1 p.m., the dead body of Manuwara, 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 was found in a pond on the back of the house of, in a pond located in the back of the house of the cousin of PW1, that is MD Saifuddin. PW1 suspected that on 25/4/2005, his daughter had been kidnapped by MD Samsher Ali, Samnur Ali, bracket Mir Hussein Ali, Mrs. Jolekha Bibi, Miss Jarina Bibi, and Rafiq Hussein. who are the, come bracket respondents, who had committed, who had murdered Manu Vara and thrown her dead body in the pond. Belsol, PS case number 41 of 2005 was thereafter registered under section 302 Act 364 IPC. The after Yes, sir. After investigation of the case was completed by the case IO, charge sheet was submitted to. Having found a prima facie case under section 364, Act 302, Act 34 IPC against the response. The learned trial court thereafter framed charges under section 364, Act 302, Act 34 IPC against the response. To which they pleaded not guilty and claimed to be done. With that. Huh? But how do you put in the statute? One zero six. 106. Twenty-eight. Stop. Next para. Though the case IO had listed 28 prosecution witnesses to bring home the charge under section 364, Act 302, Act 24 IPC. The trial court examined only 15 prosecution witnesses. Thereafter, the thereafter, the respondents were examined under section 316 ARP. Wherein they all took a stand that the evidence adduced against them were false. Yes, sir. Yes, sir. The learned transport thereafter came to a finding that there was no iota of evidence about the alleged kidnapping of the deceased and that the case of the prosecution had been based on concoction and surmises without any convincing and cogent evidence to inspire confidence on the credibility of the witness and the evidence adduced by them. As such, the learned trial court held that the prosecution had been unable to prove the case beyond all reasonable doubt. Consequently, the respondents were acquitted of the charges framed against them by giving them benefit of doubt. Next up, the learned PP submits that the learned that the impugned judgment passed by the learned trial court acquitting the respondents is not based on any evidence, is it? Or is based on evidence?
Not. Lordship, learned trial court has not taken into consideration the entire evidence on record.
Certain facts
Evidence on record, entire evidence on record.
has not taken into consideration entire evidence on it. In as much as the evidence of PW, Arenas. But Arena is like you. And when who said that she was pregnant?
I've started to understand that.
It's
No. Mother.
Yes, PW2, Marcus.
There is the fact that PW2, who is the mother of the deceased, had stated in her evidence that the accused Jarina Begum had admitted before the police and reporters in presence of villagers that the victim was in love with the accused Mir Hussain at the time of her death and that she was 2 months pregnant. Further, as there was some deformity on the upper lip of the deceased, the family members of the accused of Mir Hussain, who is the boyfriend of the deceased, did not agree to the marriage between the deceased and Mir Hussain. As such, PW2 is suspected that the accused had murdered her daughter, Munawara. I thought, did she say this before the police in the 161?
Who, Myla? PW2.
I did not state before the. I did not state before. Yeah. Case denied in her cross.
Even about love affair, PW3 has also said.
No, what I'm saying is
Regarding the pregnancy part.
pregnancy, love affair also.
Apart from PW2, PW3 has also said. Not about the pregnancy, but about love affair.
Where is that?
PW3 page 16.
Yeah.
In between, accused Mir Hussain had a love affair with Manwara.
It is not a fact that I did not state before police. He replied, well, is this there in the 161?
Okay. Evidence of PW2, my lord. Statement of PW.
Evidence of PW3.
Three. Mortinul Hoff.
Ah. To stop. Make it. No, continue. No, continue. You also submit the additional PP further submit the PW3 in her first examination had stated that he had told the police that Jarina had told the police that Mir Hussain had a love affair with Monowara and that Jarina had taken away Monowara. The law PP also submits that the evidence of PW2 is to the effect that due to the deformity in the upper lip of the deceased, the marriage proposal of the deceased with her boyfriend Mir Hussain had been rejected by the family of Miru.
He has mentioned in 161. Monwar Samsar regarding TV, watching TV, Sabolo Jakiator Korolo Jai are Monwarar, Samsher Laura Muhammad, Mir Hussein Ali Logot, Halpua Asil Buli Moy Janu. It is a statement of Motinul.
Okay, they had a laugh of it, that's all. Earlier you had said that who is Shamsher Ali?
Accused persons, one of the accused persons, Samsher. And the father of the Mir.
father.
Yes. Father of Mir Hussain, with whom allegation is that the
But
girl.
Humid Ali is the father of the victim. No, okay, Shamsher Ali is the father. So some next time. And what else? What else did you say?
Hello?
What else was your submission with regard to this case? I
The
don't know what.
motive part, because circumstantial evidence, motive is an important factor. So, like what I tried to submit before this honorable court, the motive in killing was there since they objected to the marriage because of the deformity on the part of the girl, and she was carrying pregnancy. So, Lordship, this is one of the factors.
Last scene with whom?
Daughter of Samsher, sister of this one, Mir Hussain. And witnesses have seen, yes, she's also an accused. Yes.
And because she had also gone into the house of.
Yes. Witnesses said they saw her entering the house but did not see her coming out from the house. And two of the not the witnesses, but charge sheeted witness, but they were their name in the charge sheet.
You mean that those two girls, those two, Fatima and Bulu or something like that?
Yes, Fatima and Bulu. They heard the cry of the girl.
Okay,
from
right.
the house of the accused person.
The learned addiction, the learned addiction statement happened. That the entire evidence against the respondent is circumstantial evidence. In as much as the deceased was last seen with Jarina. Yeah, last seen with Jarina what? Jarina Begum, who was the sister of Mir Hussain, the boyfriend of the deceased. Hussain. The deceased was also 2 months pregnant. Hussain. Further, further PW6 had stated that he had seen the deceased and Jarina, accused Jarina, respondent Jarina, entering the house of Shamsher Ali, who was the father of Mir Hussain. Further, the evidence of PW1 was to the effect that he came to know from one Fatima and Bulu, F-A-T-E-M and Bulu, B-U-L-U, that they had seen the deceased entering the house of Shamsher Ali and crying inside the house of Shamsher. The marriage proposal the proposed marriage of the deceased and Mir Hussain had also been rejected by the family of Mir Hussain as the deceased had a cleft lip. Cleft lip. Was it a cleft lip or what? What?
Cut mark also that will be.
It's known as the cleft. Had a cleft lip. He does submit that due to the above fact, there was motive present on the part of the respondent to have killed the deceased. Accordingly, submit that the impugned judgment passed by the learned trial in acquitting the respondent has been done by not taking into consideration all the important evidence that has been adduced by the prosecution witness. Accordingly, praise that the impugned judgment should be set aside and
Two more circumstances.
what?
These accused persons were found absent from the 25-4, they were found absent, my lord. They were not.
All of them.
All of them were not there. And there's extrajudicial confession.
The evidence?
Yes.
What have I said out? And should be set aside, and the appellant and the respondent should be convicted under section 302 IP as 302/34 IP.
Lordship, page 10.
Yeah,
Regarding the absent part.
the murder of the deceased has been proved by the evidence. Page 10.
Page 10, in between, my lord, between. Since 25/4/2005, all the accused persons were found absent in their house, and the house was under lock and key.
Where? Page 10.
Page 10, it would be around 10th line. 9. 9th line.
Since. Who is this? This is father.
Father.
What does the police have to say about this?
Police. IO. IOPW 15. They were later on arrested because there was no affair.
No, okay. In
From
this,
354 lordship,
in this 161 statement of PW1,
my lord.
did he say that this house was locked and all? They were not there.
My lord. Hamida. The gentlemen are waiting, my lord. Lordship will take up at 2, my lord.
Gentlemen are waiting.
They are waiting.
Who's waiting?
Because of the time, my lord, 105.
Oh.
At 2, my lord.
Oh, oh, we can complete it also, then we can relax.
Shiv them, my lord. Let us see.
Otherwise, you see, again, we've got to again after the.
My lord, Hamid Ali, let us see.
For all of you all also, better. Because I don't think we've got any matter after it.
One more is there.
One more, though, we can do it after lunch.
That's true. Then after lunch, then
No, with this flow, with this, this only this aspect.
my lord, Hamid Ali.
Here it take time. Or what?
Yeah, because
Why?
he wanted to place the I, but it's for hearing lordship. Paper book is also ready, so he.
What for what case?
It is not.
I have for bail, your lordship.
Under which case? Under which?
Sorry, Section 4, your lordship.
Section 4.
I is pending since long, your lordship.
Okay, you just wait. We'll take it up. We won't take more than 5 minutes. Wait.
Hamid Ali is seeing you. Hamid Ali. He hasn't mentioned in 161, Hamid Ali. Even PW8 says,
Huh?
PW8 says at page 33, I went to the house of Jerina searching for Manwara, but we found the house under lock and key. Since the time Manwara went missing. No, in substantive evidence before the court at
Who
page
said that?
33.
PW8.
PW8, page 33. 26/4 till the dead body was recovered, the house was under lock and key.
33. Who is this PW8?
PW8 is Abdul Hai. Yes, yes,
Brother of that.
brother of the deceased.
On 26, I went to the house of Jerina. No, where?
Page 33.
33, yes. We also searched in the house of the.
No, second line.
Uh.
On 26/4, I went to the house of Jerina searching for Manwara, but we found the house under lock and key.
House Jerina is the sister of the
Married sister.
They used to stay together.
right? Where?
Married is the different.
House of Jerina. When
Sketch map, my lord.
Serena is a married daughter. She lives there. Separate house. Yeah, that's good.
Jerina is married. Unless all son-in-law is staying with
That is not
Jerina's house.
clear from the prosecution case where she used to stay. My lord.
If that is not clear, whose fault is it? You are the prosecution. You cannot. You're starting to blame your own enforcement agency.
No, it has to, your lordship, because see, lordship, but effort has been made by the court itself by sending several summons, but they did not enter the appearance.
No, what to
Because
do?
of these two witnesses, our case has been demolished, madam.
Which two witnesses?
This Bulu and Fatima, they heard the cry, they saw her entering. Lordship, our fault, my lord. Prosecution agency as well as responsibility of
See, one
also, my
thing.
lord.
On 26/4/2005, I went to the house of Jerina searching for Manara, but could not. But the house was under lock. Could have gone again on 27. Could have gone on 25th. Could have gone on 28th.
No, since they say the dead body was recovered, it was lock and key, they might have gone.
You do not know. That does not say that. It only says that on that particular day.
No, then thereafter the line. Lordship, may kindly see the next line. Since the time of Manwara went missing till the time of recovery of a dead body, the villagers and our inmates visited the house of Jerina, but I do not know what they found there.
That's not. You visited the house. Doesn't say that it was lock and key after that.
Then we also searched the house of other accused looking for Manwara.
So nowhere.
They made endeavor, villagers as well as family members. My lord, it was not.
And it doesn't say that they were not there in the house also.
It was under lock and key.
No. You cannot add words where it is not there. At that moment, you do not stay in your house 24 hours a day. You have to go out sometime. You cannot leave it open.
Village area, people will know, my lord, whether they're there or not, my lord, because lordship, they know each other.
What about Jerina's husband?
He is not an accused, but she is lordship. Maybe apprehension when the wife was not there, police might pick him.
Not being.
It happens, your lordship, and
Any another aspect you wanted me to add? Of you said that. What did I say? What was the thing? What was this? This thing I was giving. The dictation I was giving. No, just before that coming, I had to cut. Then after that. And then. Yeah.
then extrajudicial confession.
Okay, you just say the learned APP also submits that the extrajudicial confession of
Not that, PW5 informed PW6 that last night Mir's father informed PW5's father how he killed Monwara.
father informed
PW5's father
PW5 father.
how he killed Monwara.
Last night means when? Which night?
Might not be in lordship, but he doesn't say when he deposed evidence.
See, when was the father of Mir Hussain arrested? So you mean to say prior to his arrest he said this, or after his arrest in police?
No, may not be after the arrest.
So that means he did not run away from the village. He was there in the village, talking to everybody else.
Lordship, I leave it to you, Lordship. I've already written. Appeal is dismissed, my lord. Lordship, put it, my lord, if Lordship wishes.
No, this is their submission. Okay, we'll put
My
it.
lord.
This
When he
is
was
the
arrested, my lord.
that the submits that PW5 informs PW6
Yes.
that the father of the
Somewhere?
number that the respondent number. What is the respondent number? Shamsher Ali is what respondent?
No, no, Samsir Ali is the accused person.
But he's a party here, no? He's a respondent number.
Samsir, number one.
Respondent number 1.
Yes.
Bracket Shamsher Ali, comma, had informed PW1
Yes.
that informed PW1 what? How he killed.
PW5 informed PW6 that last night Mir Hussein's father informed PW5's father.
That Shamsher, the respondent number 1, bracket Shamsher Ali, bracket close, had informed the father of PW5.
How he killed Monwara.
He had killed
Monwara.
the deceased Monwara.
My lord. Some said and I arrested so and so it is written here, but on which date it's not given, my lord.
Where is that?
Five days.
No, no, it has lordship. Lordship, page 25, PW6.
25. Okay.
In between 7, 8. When I went to dump cow dung at noon time, I met PW5 Sahidul. He said to me in this manner, last night Mir's father Samsher went to our house and told my father as to how he had killed Monwara. And I was hearing this thing. But PW5 doesn't himself say anything.
This PW6.
No, PW6 talks about PW5 is silent about it.
Correct. What have I said there out there? What has PW5 said? The learned additional PP submits? No, PW6 stated. PW6 stated in evidence that PW5 had informed him that the respondent number 1, bracket Samsher Ali, informed the father of
Went to their
PW5
house.
that the manner in which he had killed Munwara, the deceased. Okay.
Right. Even forensic was also done, nothing has come out.
But PW5 does not say that.
No, he remains silent.
It was said. Now, when did he say it? After his arrest, probably. And if it was,
Nothing is
if
there.
it was not after his arrest, that means he was not running away.
Oh, doesn't mean, my lord. Doesn't mean, my lord, he will remain at this place.
Otherwise, everybody, according to you, everybody was searching for them. They had all run away, lock and key, all their houses.
It has come up on evidence, my lord.
That's what I'm,
My lord.
but when you think about,
My lord.
if he had the chance to talk to the father of respondent number 5 prior to his arrest, that means he had not run away. Or
After is no use.
PW5 was harboring a fugitive, protecting him from arrest. I don't. Anyway, that's all. Anything else? Next, para. Mr. Jai Borbuya, learned counsel for the respondent number, for the respondent, submits that there is no evidence to prove that the respondent had killed the deceased. He submits that no evidence, no, that Fatima and Bulu, who were listed as prosecution witnesses number 13 and 14, did not adduce evidence before the learned trial. 13, 14. This has been clearly spelled out in the evidence in the cross-examination of PW6, wherein he has stated that PW6. Page 26. PW5. No. 6. No, no, no. No, yeah. Inasmuch he had stated that he had not seen the deceased entering, the deceased and Jarina entering the house of the respondent number 1, bracket Samsher Ali. That's all. Okay, basically, continue this. It will take some time, but yes, your thing. We just hear you. Yes.
Applies.
Section
4, appeal against conviction.
What is your, what, on what ground?
Let the matter be taken up after.
No, where is the, please tell us. What is the basic thing?
The thing is, my lord, in the statement of the victim under 161, 164, and the evidence in chief, my lord, are not corroborating. Are not corroborating. There is.
Are not cooperating.
My lord.
How old is the victim?
Victim at the time of occurrence, 15 years.
Main case.
Main district.
My lord, if possible, my lord, I may be dispose of my lord, if possible. I is pending, my lord. So.
IA is pending. We'll dispose of both together. IA and the appeal.
Then, my lord, if possible, my lord, after.
We hearing you. Let us see.
In this case, my lord.
Let us see the FIR.
FIR, my lord, that is for your lordship. Page 5 is the relevant part. Humble submission is that my minor daughter, Ruxana Khatun, 13 years old, had been missing from yesterday. Around 5 a.m. today, that is on 30/9/2018, I have come to know that last night, the below named accused person called my daughter by making a phone call to her from the mobile phone number so and so on the pretext of marrying her. But the accused, in collusion with 4 unknown accused persons, gagged my daughter and took her to some unknown place in Dharmasala Part 4. In furtherance of a previously hatched conspiracy and after committing rape on her under a bamboo gourd, he handed over to the 4 unknown accused persons. When the unknown miscreants tried to commit rape on my daughter and outraged her modesty by removing her clothes, she ran away from that place to save her life and took shelter in the house of a family in the side village. Around 4 a.m., when the members of that family noticed my daughter, they started questioning her. Just then, the accused arrived there searching for my daughter. And as she identified the accused, the people present there caught him and informed me about the incident. This is the FIR, Your Lordship. FIR was registered under section 366A, 120B, 341, 376D, and 354 IPC, read section 4 of POCSO Act.
Lordship, PC. What is 366A?
366A, my lord, this is kidnapping.